Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for joining us for this post-argument episode of SCOTUScast. I'm your host, Spencer Karen. On November 10th, 2020, the Supreme Court heard oral argument in Texas v. California. The issues before the court were whether the unconstitutional individual mandate to purchase minimum essential coverage is severable from the remainder of the Patient Protection and Affordable Care Act, and whether the district court properly declared the ACA invalid in its entirety and unenforceable anywhere. Iyla Somin joins us for this special extended edition episode of SCOTUScast. Mr. Somin is a professor of law at the Antonin Scalia Law School of George Mason University.
Thank you so much. I'd like to thank the Federalist Society for organizing this event and all of you for listening in. And I should also note right off the bat that I do have at least a small involvement in this case in that I joined an amicus brief along with several other legal scholars arguing that this provision of the Affordable Care Act is in fact severable from the remainder of the act. The brief didn't take a position on the other issues in the case, so I should note that what I say, particularly on those other issues, it just reflects my viewpoint, not necessarily those of the other people who are on the brief. I should also note I don't have any financial stake in this case, except to the extent that, like almost everybody, my health insurance is to some degree affected by the future of the ACA. So before going into the details, I'd like to end the suspense, or such suspense as remains, and say that while there's a lot of things about the outcome of this case which remain uncertain, one thing that is very clear after oral argument is that this case almost certainly will not lead to the collapse of the entire ACA. Maybe what's left of the individual mandate will be struck down, and that will set an important legal precedent. Maybe the court will say that the entire case has to be thrown out based on standing, but the one thing they almost certainly are not going to say is that the entire ACA has to go as a result of this. I think that kind of outcome was never very likely, but it is certainly clear from the oral argument that that's not going to happen, even though obviously in the political arena and in the media, this possibility has been much discussed over the last few months. So I'm going to start off by talking briefly about the history of this case and how we got there. Then I'll talk about the severability issue, which I think is the most important issue, at least from the standpoint of healthcare policy. I'll also talk about the question of the constitutionality of what's left of the individual mandate, and also the issue of standing, which is perhaps the most uncertain aspect about what the court might actually do. So how did we get here? As I hope most of you know, 10 years ago, Congress enacted the Affordable Care Act, also known as Obamacare. One provision of the Affordable Care Act that was considered very important at the time was the individual mandate, which required nearly all Americans to purchase federal government-approved health insurance or pay a fine if they failed to do so by a certain date. This individual mandate was famously challenged by a wide range of different plaintiffs, including many state governments, in a variety of cases in 2010, 11, and 12, and this culminated in NFIB versus Sebelius, decided by the Supreme Court in 2012, where the court ruled, on the one hand, that the individual mandate could not be justified under Congress's powers under the Commerce Clause or the Necessary and Propers Clause. I think, by the way, that ruling was correct, and I argued in great detail at the time in various publications and amicus briefs that that's what it should be. But in his controlling opinion for the court, Chief Justice John Roberts ruled that the individual mandate nonetheless could be preserved through what he called a saving construction, that it could be interpreted as a tax. And there are a number of different reasons why he thought it could be interpreted as a tax and therefore needed to be interpreted as a tax to avoid striking down the law. But one key reason was that it raised revenue. That is that people who violated the individual mandate, they had to pay a sum of money, and that money went into the Treasury, and so that makes it much more like a tax than it might be otherwise, the fact that it can raise money. So then it seemed like Obamacare had survived, at least most of it survived. The court did strike down part of the Medicaid expansion. It also survived another lawsuit in King versus Burwell, which was a statutory interpretation case where the court ruled 6-3 against the plaintiffs. And of course, then in 2017, the Trump administration came to power, and the Republicans had control of both houses of Congress, and they promised to repeal Obamacare. The getting rid of Obamacare, that idea was going to be made great again. But sadly or happily, depending on your point of view, that didn't occur, and the Republicans largely failed in their efforts to repeal the statute. What they did manage to do, however, in December of 2017 was to reduce the penalty in the individual mandate to zero. They didn't remove the actual text of the mandate as such, but they did remove the penalty. So the penalty is now zero. In 2018, the next year and a few months later, 20 state governments led by the state of Texas, all of these were conservative red states, filed a lawsuit in which they argued two things. First, the individual mandate is now unconstitutional because it can't be considered a tax anymore due to the fact that it doesn't raise any money. If the penalty is zero, it can't possibly raise any money, therefore it can't be a tax. Secondly, and more controversially, they said that because the individual mandate is now unconstitutional, the whole rest of the Affordable Care Act also has to go, not because they were arguing that part is unconstitutional, but because it could not be severed from the individual mandate or from what's left of it. The doctrine of severability, which until this case was sort of a backwater issue that only experts were interested in, it holds that as a general rule, if one part of a law is unconstitutional, then it can just be severed and struck down, but the rest of the law will remain. But in some cases, the part that is severed is so important or so essential in the lingo of the Supreme Court that the whole rest of the law has to go with it, because the remainder of the law just can't work or can't exist without the part that has been struck down. So they said this residual individual mandate was so central to the rest of the ACA that the rest of the ACA simply couldn't exist without it. And they cited legislative findings from the original 2010 Affordable Care Act, which indeed said that the individual mandate was very important to the overall structure of the ACA. Moreover, the Trump administration, at least to a large extent, actually agreed with the plaintiff states in this case and refused to defend most of the law. And so as a result, you ended up having a coalition of blue states led by California intervening to undertake the defense. So that's how the case became California versus Texas, even though originally it started off as Texas suing the federal government to get rid of the ACA. A trial judge, Judge Reed O'Connor, actually very surprisingly to most experts, ruled in favor of the plaintiffs on both of these issues, both on the unconstitutionality of what's left of the individual mandate and on the issue of severability. Obviously, the case was appealed to the Fifth Circuit, and in a decision of December of last year, the Fifth Circuit in a 2-1 ruling, they upheld the judge on the point that what's left of the individual mandate is now unconstitutional, but they essentially told him to do a do-over on the issue of severability. They They said his severability analysis was flawed in a variety of ways, including that he was relying on the 2010 findings as opposed to the intent of the 2017 Congress. But they said, you, Judge O'Connor, you have to go back and do your homework all over again, go over the issue of severability from the beginning to see which parts really are severable and which parts are not. But before Judge O'Connor could actually undertake his new homework assignment, so to speak, the Supreme Court intervened and they decided to hear the case. And so that's what we had oral argument on last Tuesday. Obviously, the case cannot be remanded back to district court, if at all, until the Supreme Court finishes its work. So I'd like to first look at the severability issue because for obvious reasons, that issue is the one that has attracted the most attention because that issue could potentially determine the future of Obamacare. And if you look at what happened in the oral argument, there is at least 6 out of 9 justices who clearly think that what's left of the individual mandate should in fact be severable from the rest of the ACA. And based on that, I conclude, therefore, that the ACA will survive largely as is. The only thing that might fall is what's left of the individual mandate, which just isn't that significant anymore anyway, precisely because the fine was zeroed out. That is, there's no fine anymore. There's a payment of zero that you have to do if you're in violation. So, for example, Chief Justice Roberts said, it's, quote, it's not our job to get rid of the entire ACA just because this individual mandate or what's left of it might now be unconstitutional. Justice Kavanaugh said that the severability analysis here is easy, and he repeatedly noted in statements and questions to some of the lawyers for the two sides that he thought that the obvious right solution to severability to that question is just to say that what's left of the mandate is severable from the rest. Justice Samuel Alito made an interesting airplane analogy. He said that originally when the ACA was first designed, it was thought that the individual mandate was like an essential part for an airplane without which the airplane would crash. But then he said that part got taken out in the 2017 tax law and the plane is still flying, and therefore it's clear that it's not actually essential to the overall ACA, and therefore these 2010 findings just aren't relevant anymore. So at least those 3 conservative justices, plus I think pretty obviously the 3 liberal justices, they're all inclined to say that this is completely severable. The other 3 justices, Gorsuch, Thomas, and Barrett, we don't really know where they stand, at least not based on the oral argument, but it's notable that none of those 3 even spent more than very minimal time on severability in the argument at all. And it seems to me if any of them were inclined to say that it's not severable, they would have at least talked about the issue. Moreover, as I wrote about in some detail during the confirmation hearings for Justice Barrett, in those hearings, she strongly hinted that she has a view of this case pretty similar to that of Kavanaugh. So while I think the 6-3 is sort of the minimum majority probably for the ruling that this is severable, it could easily be 7-2 or 8-1 or even potentially 9-0. And I think this is actually entirely understandable because the severability argument for the plaintiffs in this case is actually extremely weak. First of all, the idea that the 2010 findings are the ones that are relevant, that just doesn't make much sense given that those findings relate to the mandate as it was enacted in 2010, i.e. with a penalty, as opposed to the mandate that exists after 2017, which has no meaningful penalty at all. And it seems to me, to the extent that what matters is the intent of Congress. It's the intent of the Congress that made the law as it is today, not the intent of the Congress that made a previous version of it. And the intent of Congress is, in fact, the standard that current Supreme Court precedent on severability says should apply. It seems to me it's very unlikely that Congress would intend that a provision that is almost completely toothless is actually central or essential to the rest of the law. That just doesn't make much sense. You can also view view it a different way and say, okay, forget about intent. Maybe there's no such thing as intent. We can't really tell what 535 people are collectively thinking. Just look objectively at whether or not the ACA can function without the individual mandate. I think it's pretty obvious that the ACA can function as well, or in my view, as badly, without an individual mandate that is now toothless as it can function with a toothless mandate. In fact, there's very little difference between the two situations. Justice Thomas has a somewhat revisionist view on severability that he has advanced in a number of recent Supreme Court opinions. The full implications of his view for a case like this are not entirely clear, but it seems to me that it too probably lies in favor of concluding that this is severable, because Thomas argues that the part that should be struck down is whatever part is essential to remedying the injury suffered by the plaintiff, with the injury being limited to whatever part is unconstitutional or illegal. And here, such unconstitutional or illegal injury as there is surely comes from the mandate itself, and therefore getting rid of what's left of the mandate arguably can cure the injury, though the question of what exactly counts as a relevant injury under Thomas's view, I think that is a little bit disputable. So there's a number of different schools of thought on what qualifies as the right approach to severability, but I think under any plausible theory of severability, this particular type of provision is severable. And I should add, by the way, that there's nothing in the text of the law which says that it's not severable. So if there had been a provision which said, if any one part of this law is struck down and the whole rest must fall, then that would be good evidence that Congress said everything is essential. But Congress did not say that. Even in the legislative findings from 2010, it didn't say that. And those findings, I think, just simply don't apply to the form of the individual mandate that exists today. The last point I would make on severability is that this result, or this likely result, I should say, should not be a surprise. It was very much prefigured by what many of the Supreme Court justices, including several of the conservatives, had said in the robocall case just last June, or this June, where they made clear, Kavanaugh, Roberts, and others made clear that they thought there should be a very strong presumption in favor of severability. And one of the opinions, they even indicated that the tail should not be allowed to wag the dog, that a small, insignificant provision shouldn't be allowed to take down an entire law with it. And if this isn't an example of a tail wagging a dog, it's hard to imagine what would be. Now, there are obviously two other important issues in this case: the constitutionality of what's left of the mandate and also standing. I'll take the issue of the constitutionality of the mandate next. In my view, what's left of the mandate is clearly unconstitutional. Roberts and NFIB gave various criteria for why the individual mandate could be considered a tax as a way of saving the statute from unconstitutionality. There are several different criteria there, but one of them clearly is that it must be able to raise at least some revenue. A law that can't even in principle raise any money just can't be considered a tax, and I think that's pretty obviously the case here, that when they zeroed out the penalty in 2017, they made it so it couldn't possibly be a tax anymore. In my view, actually, Roberts got it wrong back in 2012, and it was never a tax in the first place and never justifiably defined as such. But even if he was right, then under his own criteria, this just doesn't work anymore. However, both in the briefs and also in the oral argument, a couple other possibilities were considered. One is that in the aftermath of zeroing out the penalty, this provision is just a nullity. That is, it just doesn't do anything because it, in effect, it issues a command, but it's a command not backed by any kind of penalty, and therefore it's a nullity. And so it could be saved from being unconstitutional because it doesn't do anything at all. To my mind, that's not entirely right because you can perfectly well imagine a command which is a meaningful order where you're trying to get somebody to do something, but also not backed by any kind of threat of punishment. I give orders like that to my 5-year-old daughter all the time. When I there are times when I say, you must go to bed right now, and she knows and I know that if she procrastinates, she's not actually going to be punished. I'm not going to lock her up or send her to prison or anything like that. But she also knows that I genuinely do want her to go to bed at that time, and that what I'm saying is not just some kind of a nullity. And there are even a few provisions of law which are like that, such as the flag code, for example. The flag code has all sorts of guidelines for how you're supposed to treat the flag, but there's no penalty for violating them. So, you're not allowed to drag the flag on the ground under the flag code, but if you do so, you won't actually be punished because there's no penalty provisions. Another way of looking at this, which might save it from unconstitutionality, is to say, well, it's not really an order or a command. It may not be a nullity, but ultimately it's just a suggestion that this should be interpreted as just, the federal government's or Congress's opinion that it might be nice if people bought ACA-approved insurance, but it's not at all mandatory. I think this just doesn't fit the text of the language. And the text of the language says that affected people, quote, shall purchase this health insurance. Shall strikes me as a command, not just as a suggestion. And in interpretation of other statutes, words like shall usually are thought to imply commands, not just statements or suggestions or random comments in a conversation or something like that. So I don't think this argument really works either. As I interpret the oral argument, I think there probably is a majority for the proposition that what's left of the individual mandate is unconstitutional, but I admit I don't know that for sure, and there are at least a couple justices where it's just not entirely clear to me, always not for certain, where they stand on this. So that's an issue to watch, not because it matters much for the future of the ACA, but because it does have some significance for the future in that it's important to establish the idea that under Roberts' reasoning in NFIB, you can't have a tax unless there's some raising of revenue. And I think this, among other things, would reaffirm the principle that you can't disguise an otherwise unconstitutional federal mandate as a tax if the penalty for it is something other than paying a fine or paying a monetary penalty. I think perhaps this is already clear or implicit in NFIB, but it would be good to reaffirm that. So I think this has some significance for future cases, even though it will matter very little for the future of the ACA. Because the residual individual mandate already plays little, if any, role in how the ACA functions. Finally, there is the issue of standing, and this is actually the issue on which the justices spent the most time in questions, and I think they're really struggling with this, and it's far from clear to me whether the court will rule that there is standing for the plaintiffs here, and if so, on what basis. And if they rule against standing, it's not entirely clear to me on what basis they would rule that. So I'll just mention a few different theories of standing which are at stake. One is the idea that the simple fact that there is a mandate creates a legal obligation, and that therefore you can have standing that harms you, even if there's no penalty for violation, because it's still an imposition of a legal duty. This would at least give standing to some of the individual plaintiffs, individuals who want to avoid getting Obamacare compliant health insurance. It might not give standing to the 20, now actually 18 state governments, but if some plaintiffs have standing, that's sufficient. Another possibility is that you can have standing that's specific to the states based on what the Supreme Court said with the special solicitude for state governments on standing created in the 2007 case in Massachusetts versus EPA. This issue, surprisingly, actually didn't get discussed very much in the Supreme Court oral argument, but it's a possibility. And I think the issue of whether states should get special treatment on standing is, I think, at least potentially raised in this case. It is raised in this case, although the court could potentially avoid having to deal with it if they grant standing on another basis. Another possibility is that the supposed lack of severability itself can grant standing, and that some of the plaintiff states argue that even if the individual mandate doesn't harm them, the fact that as a result of it, some additional people might either go on Medicaid or buy Obamacare compliant health insurance, even if it's just a few of them, that might indirectly negatively affect the states. It might increase their public expenditures or affect them in other ways. So that can be an indirect effect of standing. And related to that is the idea that even if the individual mandate as such, or even in its indirect effects, even if that is not enough to give them standing, maybe the fact that it's tied into these other provisions of the ACA, that's enough to create standing on the basis of inseverability. And on this theory, the court would have to decide the severability issue before it could decide standing, because whether there is standing turns on whether there is severability or not. That is on whether getting rid of the remaining individual mandate would also get rid of all the rest of the ACA, which on this theory is the part that really harms the states, or at least has some negative impact on them.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.